After 3 years, numerous postponements and the recall of witnesses, the state has concluded its case against the 5 men accused of murdering Senzo Meyiwa. In July 2023, Judge Rangata Mokgoatlheng took over from Judge Tshifhiwa Maumela, who was unwell and later suspended, leading to the case restarting. The defense is now expected to take over on the 7th of August when the trial resumes. Let's get a sense of whether the state has done enough in arguing its case with legal analyst and managing director of Donda attorneys, Melusi. A very good afternoon to you, Mr. Xulu. Thanks very much for your time. You've spent quite a great deal of time following this case, especially in the past 2 years when the restart button was actually pressed. What, for you, were the highs and lows?
Good afternoon to you, viewer, and to the viewers at home. I think what was interesting for me was the fact that the matter has to start de novo or start afresh. It's not something unheard of, but I think for a high-profile case, it was quite interesting to see. What is a low for me? Something that's I think it's an elephant in the room. The fact that there are witnesses who were in the house that were not called, that I think were crucial, especially because Katie had a relationship with Senzo Meyiwa. One would have loved to see her, narrating what happened when the love of her life was allegedly killed on that day. But that the state did say they are at liberty to call Kelly Kumalo, her mother, and even Mary Peary, who cleaned the scene allegedly, or when this incident happened. So I would have been very happy to see those witnesses because there are certain questions which I think are important for them to answer.
I guess, it's precisely what people have been talking about over time. It is indeed, the elephant in the room, as you say. How do you think it may affect how people see whether or not justice would have been done at the end of the day?
At the end of the day, it's not the only thing that the state needs to prove for them to get a conviction. But one would have been happy to see, the state closing all the loopholes that could be seen to be loopholes where all the relevant witnesses are called. But I suppose they'll be using what they have. What is of interest to me is this ballistic report or the chain of custody for the gun, which the ballistic expert kept at his home. But it is the main weapon that will be used. So there are one or two things, or if not a few, that one is concerned about. But at the end of the day, the question is, did one of the two accused come in the house? Were they properly identified? And secondly, were the other witnesses properly put on the scene or just at the house to say they are the ones that drove away the accused? And then there's an issue of Zungu. I hope I don't take long. There's an issue of Zungu, the police officer, Constable Zungu. I know it was in the social media that his father was, saying his son is lying. Maybe if the defense don't get Section 174, they might call Absalom Zungu to clarify that Constable Zungu was not telling the truth so that he can get promotion. So there are just a lot of interesting things here for you. But lastly, if you allow me, one is interested to know if these 5 accused were allegedly sent to kill Senzo Meyiwa, who sent them? And if there's someone who sent them, why is that person not arrested?
Now, with all that said, and with the defense now expected to take over when the trial resumes, would you say that the state, for its part, has done enough in arguing its case?
I think for me where I stand, I'm not happy with how the state dealt with the case. For me, it's not really beyond reasonable doubt. And maybe the issue might be the confessions for accused 1 and 2, and how that is dealt with. Because remember, there was a pre-trial, and the state was adamant that they did not assault or get the confessions in an unconstitutional manner, and the judge was impressed or satisfied that these confessions can be admitted as evidence. So now they have to deal with the fact that they have to say, despite the fact that the confessions are admissible, still the state did not prove his case. So I think those confessions are a problem for accused 1 and 2. But for accused 3 to 5, I'm not really entirely happy about whether the state proved his case beyond reasonable doubt. But let's see how they will argue it when they are arguing, when it is at this stage. But I just want to give a view that for the viewer, that I think what is important at stage, the defense might, before they go to the defense witnesses or the accused, they might try to apply for Section 174. And that will be interesting how they'll summarize the reason why they feel the case should not continue beyond this point.
Let's just say they don't file that application. Could the issues you've raised around the witnesses, what the state basically didn't do, could those be just the gifts that the defense needs for its case?
Yes, but it's a very tricky one, Vuyo, because here we are calling a witness who was supposed to be a state witness, hoping they will support your case. And then they come on the witness stand and maybe they're not as helpful. And then you have to declare them as a hostile witness. But in any case, there are things that have been done, probably the state witnesses, and even identifying. Remember, I always bring this up as well. The mother of Kelly Kumano, she made an identity kit and identified one of the accused, who later the charges were withdrawn. I think it's Zamo Mbata. He's still suing the state, but she said it is him who was there, who had dreadlocks, but only to find that that particular Zamo Mbata was a neighbor of the Kumanos. So why would she say this is the person who was there when he was not? So I was interested to see how she was going to explain that. But like you said, it might be a gift for the defense, or it might be a case, depending how it turns out.
Perhaps just to end it on a different note. I mean, there was the issue of Judge Mokgoatlheng's outburst, and of course, which was followed by, subsequently followed by an apology from him. Would those or such matter at all in the case?
I think the first thing I was expecting is the outburst, which was the second time. I think last day there was an outburst. This was an issue because it had racial connotations. I was expecting that after the second one, maybe the defense, in particular Advocate Psomi, might say he does not feel that the judge will be, supporting his, or not supporting him, but he would not think the judge will be the right person to continue the case because of his view, in particular to black advocates or black lawyers. Maybe I thought he was going to apply for a recusal. But what I'm looking at now is that since he's here, maybe on appeal, if they are convicted, that's an if they are convicted, they might bring up those issues. We don't know, but those issues have been there for us to see, but it depends how the defense sees them, should they not be happy with the conviction, if it becomes a conviction.
And there were people who sort of rose to his defense, that he was venting his frustration and the underlying issues. In other words, what made him say, or the things that made him say what he said, shouldn't be undermined, underestimated, or dismissed.
Yes. For instance, I think it's about him not being informed properly, or the directives or how things are supposed to be communicated to him, which is understandable. It might have affected the way the trial was being run at the time. but it's the way he raised his frustrations, and by stating things that might sound negative to black professionals. So those were things that were kind of an issue, especially from the history that we're coming back from. But yes, being professional, being on time, and communicating properly, and setting your schedule properly if there are certain events which are of especial importance to you, it's important as a professional. But it's how he raised those disappointments. But I hear where you're coming from, that he might have raised things that should be noted from a professionalism perspective.
Certainly, because I mean, the people were saying, look, this happens fairly irregularly. The difference here is that there is so much focus. I mean, people are interested in this particular case, but the courts are full of such issues and practices on a daily basis.
Yes, it was important for him to raise that. But one of the things that I've had a view on was, or the fact that there are certain things that not that they must not be discussed in public, but there are certain things that can be discussed in chambers, where if there are issues of frustration, the court can state them, or the judge or the prosecutor, so that at least it shows that there's a management of issues that should not be stated in public, because maybe you might be having certain disappointment, whether you're a legal practitioner or a judge, and then you might express that in a way that you should not express it in. That is why he has also tendered his apologies on those two separate occasions, because he also realizes that he should have not maybe stated it the way he has stated. But I agree with the fact that professionalism and doing things right is important for everyone to see, even if it's not a case that is high profile for that matter.
Melusi, thank you very much for your time. Managing Director of Donda Attorneys. He spent a considerable amount of his time following this case, and we've been calling on people like him ever so often to come and unpack the issues that have come through during the course of this case. The defense is now expected to take over on the 7th. That's when the trial resumes, now that the state has actually concluded its case.